The Uncovered Lamp says Judge Borowski for a Judge Judy type show. Well, he's still a judge. He's still a sitting judge in Wisconsin. They're just moving him to a different judgeship instead of being. He had the if you don't remember, he had the major felonies bench, which meant it was all murders, kidnappings, and sexual misconduct cases. That's all he handled, basically. Major assaults, I guess. That would be, anything that was a major felony would be in his courtroom. And that probably takes a huge toll on him. And we're going to talk about that actually as we go.
Cheers, the motherfucking tea.
So this is from one of the locals community members. He says, I practice in Milwaukee. Borowski screwed up on a bail review shortly after the Darrell Brooks fuck up by a Milwaukee court commissioner. He's been a target for the left for a while for criticizing liberal city leaders. The bail fuck up opened the door to this and gave the chief judge the political cover to reassign him. The Milwaukee County DA, Soros-funded, fucked up Darrell Brooks's bail. He wasn't supposed to be out of jail when he ran over the parade. Liberals were taken to the woodshed for this. Borowski had zero political cover because he fucked up a bail after the parade incident. He fucked it up given the political environment. He could have remanded without bail, but he didn't. The defendant committed a serious crime soon after Brooks ran over the parade. This is all a planned takedown of a judge that speaks out against the Milwaukee political machine. This reporter is a political animal and often collaborates with the political leadership. Consider everything written to be crafted to form the worst version of the narrative. Almost all of us at practice in Milwaukee really like Borowski, but everyone also thinks he fucked up the bail decision, which allowed all of this spiral. There was also a rush to reassign him from a high-profile off-duty police murder case. Last month, the Milwaukee medical examiner was forced out of office, which has jammed up the case. Medical examiner was supposed to testify. It would have come out that medical examiner was forced out because he was about to expose COVID death fraud. So there you go. Hot damn. Straight from the fucking, from the lips of a Milwaukee attorney. So very cool. Thank you for that behind the scenes update. You can't get that shit anywhere else. Really appreciate sending that. But I figured we'd open with a Borowski clip, and then we'll read the article and kind of talk about what's been going on and my thoughts on it. Here we go.
City of Milwaukee has turned in some neighborhoods at some times into a sewer.
Tonight, CBS 58 goes one-on-one with the judge who...
Look at this. Look at this man. He is anger incarnate. He is angry at Milwaukee. City of Milwaukee has turned in some places into a sewer.
whose scathing remarks about Milwaukee put him in the spotlight this week. When he spoke in his courtroom, Judge David Borowski did not stop at calling Milwaukee a sewer. He had a lot more to say. And elected leaders were also one of his targets. CBS 58's Victor Jacobo talked to the judge today and joins us now live from the newsroom. Victor.
That's right, Natalie. Judge David Borowski says he's seriously concerned about the dramatic rise in crime over the last few years in Milwaukee. He says it's on the community as well as city, county, and state leaders to step up and do something about it.
I think it resonated because I was saying rather bluntly something that I think a lot of people are thinking.
Reflecting on his strong words in court last week, Judge David Borowski told me his reaction was sparked by seeing the growth of homicide, car theft, and reckless driving cases in recent years.
Because what we have right now is not just a problem, but a crisis.
He hopes his words can spark action from city leaders instead of what he says are just statements and press releases that don't change anything.
I think we need some strategies from whoever is elected mayor next month.
Wait.
I think we need some strategies.
Judge room. He's got, here's my law books. Here's my Green Bay stuff. Oh, and here's my giant frickin' Sons of Anarchy poster and my boxes. I finally got him out of the courtroom. I've been sitting in that courtroom for months. Stupid janitors wouldn't take care of them. Now they're in my office where they belong, on the floor, disheveled like you're going to be after I rough you up, you piece of garbage. Oh, couldn't Like the studio, they've got studio lights in here. They've got the camera over here. Did one guy not think, you know what, maybe we should do? Maybe we should just go ahead and move these boxes out of the room just for the shot. We'll move them out. We'll move them back in later just to clean up the shot a little bit. We're going to do these like behind the scenes B-roll shots. We're going to try and get some ankles in there, but this is great. It's just a giant Sons of Anarchy poster.
From whoever is elected mayor next month, from our police chief, from other elected officials, aldermen and others, to deal with this problem.
Borowski noted part of that strategy involves more funding for resources for the criminal justice system, which is in the hands of legislators in Madison.
I think the legislature needs to recognize that the city of Milwaukee and Milwaukee County need additional resources. Shared revenue has gone down as a portion of the county and city budgets over the course of the last 10 years. And the money that we need to deal with some of the crime issues needs to be there.
He also believes young people need a greater emphasis on patience and conflict resolution instead of resorting to gun violence to solve minor offenses.
In the old days, that would have been a fist fight. And I'd like to go back to the days of fist fighting, because not that I'm endorsing that, but two guys having it out and throwing a few punches and resulting in a broken nose is a lot better than someone pulling out a Tech 9 and shooting somebody.
I'd like to go back to the days of fist fighting.
The rise in crime can partly be tied to the pandemic, but it's not the sole reason. And he says politicians should not hide behind that.
So here we go. Here's the article though about what's going on. Again, I just wanted to open up with a classic Borowski, because it's important to realize what we are losing as we lose this man from the next murder trial in Milwaukee. Here we go. Judge seals defense brief describing his off-the-record behavior at a homicide trial. It's kind of a scandalous title. A Milwaukee County judge already facing public criticism has been transferred from hearing major felonies after the state public defender's office raised questions about his conduct in a homicide case. Judge David Borowski ordered a court filing about his actions to be sealed from public view. Now, the way this is written, it sounds surreptitious. It sounds like Judge Borowski is trying to hide his activity, doesn't it? Like that. Is that the impression that you're getting? Because that's the impression I got when I read this. And we'll get into what happened, because I see people saying off the record. Yes, his off the record conduct. But however, off the record conduct can indicate prejudice or bias or impropriety in an on the record case. That can happen. I don't know that that's what happened here. But the way this article is written, it's already set up that Judge Borowski is trying to shield his personal behavior from the public, which is not the case as we read on. But I think it may have been written to imply that was the case. Whether there's an animus towards Judge Borowski from the Milwaukee Journal-Sentinel, which is possible. Judge David Borowski ordered a court filing about his actions to be sealed from public view. The Milwaukee Journal-Sentinel has obtained a copy of the document. I want this document a lot, by the way. If anybody knows, has any connection to get this document and legally acquire the document, it would be really interesting to read, even if I can't broadcast it. The Milwaukee Journal-Sentinel has obtained a copy of the document, which details how defense counsel says Borowski berated them, offered his candid and arguably offensive thoughts on witnesses and jurors, and cut short the defense attorney's closing statement. One explanation for his actions, the two public defenders imply, was that he was upset and distracted by the media scrutiny he was under for allowing a man convicted of sexual assault to remain out of custody while awaiting sentencing. And this is an unfortunate byproduct of being a judge. All right, here we go. 10 days after he was convicted, that man, Ernest Blackney, killed his girlfriend and tried to burn down her house and some cars, and later carjacked a construction worker at gunpoint. Blackney was fatally shot by police days later after a chase that ended in a downtown bar district. In late August, Borowski was in the news for what he didn't do in court. After Blackney pleaded guilty to second-degree assault of a child on August 15th, Borowski allowed Blackney to remain free on $5,000 bail, pending his October 20th sentencing. This is very, very common. This is very common. If someone is out on bail, if someone is out on, on a bond or whatever, once they plead guilty, they tend to stay outside of jail until their sentencing, because their sentence might not be jail. So I want to point that out. It's the way they're the way they're writing this is to almost imply that this is not normal. But if someone has complied with their with their release guidelines, usually they don't go in until they're sentenced. And when they're South Texas, it's not a pretty big oops. That's what you're a couple seconds behind, but it's not a big oops. This is normal how this is dealt with. If you have someone who pleads guilty to a crime, they're out on release during the pendency of the case, which we're going to get to, and they don't fuck up, then they're going to stay out. Like, that's how it's going to go. And it's easy in hindsight to look back and say, oh man, I should have locked that guy up, or he should have locked that guy up. But if you don't have basis to lock someone up, then that would actually be an infringement of their rights. And that's tough. It's tough to deal with. This is written in a way to make it, again, to make it sound a little more nefarious than it is. Okay, so here we go. The decision came despite a prosecutor's request that Blackney be detained because the state would be recommending 6 to 8 years in prison. But you can request it, but if there's no grounds for the detention, objection, grounds. According to a transcript of the hearing, Borowski noted Blackney had no issues while on pretrial release for several months. 10 days later, Blackney killed his partner, Nakia T. Rogers, 36, of Milwaukee, set her body and some cars on fire, then committed an armed robbery. He was a fugitive until he led police on a chase September 2nd that ended with a shooting in downtown's crowded bar district. Blackney was killed by police after he crashed, exited his vehicle, and fired at officers. Both the homicide and sexual assault cases against Blackney are scheduled for formal dismissal October 31st before Judge Glenn Yamahiro. The homicide trial of Michael White. Now, this is the one we're talking about. This is the one we're talking about. Homicide trial of Michael White started August 29th, 4 days after Rogers was killed. That also was the same day Blackney was charged in her death while he was still a fugitive. White was charged in an April 2021 quadruple shooting that left 2 people dead. A jury convicted White on September 2nd of first-degree reckless homicide, reckless injury, and recklessly endangering safety. According to the post-trial brief filed by White's attorneys, Borowski held numerous off-the-record discussions with lawyers during the trial. We saw this during Edgecombe as well. Chambers, now. Chambers, now. Counsel, stop talking. Chambers. Chambers, we saw it all the time. Quite a bit. We didn't know if it was from the camera because the cameras were there and he didn't want to have discussions in front of people. But it turns out this might just be how Borowski handles cases. He talked at least twice about the Blackney case, explaining his decision not to remand, venting frustration that a retired judge offered his take on the decision in a news story, and acknowledging he was generally distracted by the media coverage of the Blackney matter. The document, titled Brief to Complete the Record, purports to summarize numerous off-the-record sidebar and in-chambers conversations Borowski had with lawyers during the trial. Borowski ordered it to be filed under seal. The Journal Sentinel has obtained a copy. They probably got the copy from the public defender's office, if I had to guess. If I had to guess, that's probably where they got it. Some in-chambers discussions focused on evidentiary issues, topics normally put on the record immediately afterward. They were not, according to the brief, The defense said making them part of the record is necessary for an appeal. The defense should have asked to make them part of the record immediately after leaving chambers. That is what you should do. We've seen this in most of the trials we cover where there's an evidentiary issue that is brought off the record in chambers. Once they are back on record, they summarize what happened, usually at the request of the objecting party, because that's what you have to do. The defense said making them part of the record is necessary for an appeal. In other discussions, he sided with the defense. For example, the judge agreed the prosecutor and state witnesses should not refer to a man who was killed as a victim since his shooting had been ruled self-defense. Borowski also criticized the lawyers' tactics and strategies and their cases, and harshly criticized some witnesses and a juror, according to the brief. So I'm not surprised by any of this because we just watched it in the Theodore Edgecombe trial. It's the same. It's how he conducts his courtroom, and I don't know that there's anything wrong with that. There's one thing in this article that I find to be a problem. We'll get there in just a minute. From Borowski. It also says he interrupted defense counsel Amanda Parent's closing arguments 4 times. One led to an in-chambers discussion in which Borowski paced and gesticulated. What's he doing? He's pacing and gesticulating. While yelling at Parent and calling her closing one of the worst I've ever seen. One of the worst closings I've ever seen. Gosh, I want to watch this trial so bad. I want to know how bad this closing argument was. Oh, it sounds terrible. Like what? What the hell is going on here? Like how bad must this closing argument have been? He then chastised Assistant District Attorney, that would be the prosecutor, Ian Vance Curzon, for not objecting himself during the defense close. Why didn't you object? Object, you idiot. And told the prosecutor how he should counter Parent's points during rebuttal. That I have a problem with right there. And that might actually be grounds for a mistrial. If it's true, but it's off the record. It's off the record. Lastly, he told Parent she had 10 minutes left. You have 10 minutes. You have 10 minutes. Get done. Get done, you dummy. Gosh, I wish I could have been there. I wish I could watch it. All right. Next, we've got the brief states the interruptions and scene in the chambers prevented Parent from completing her prepared closing argument and effectively representing White. I mean, maybe it did, maybe it didn't. This is the reminder that this brief is filed by the defense and is going to be written in their favor about why they didn't do a very good job. And it's Borowski's fault. So that's one thing to kind of keep in mind. Borowski mentioned during several in-chambers discussions, he thought a juror had been sleeping during the trial, and he thought the juror might be slow or autistic. I want to call your attention to juror number 4, sleeping again in the courtroom. I don't know, maybe he has autism, probably in the locals chats on Recato Law. Probably there. Let's see. The lawyers had not initially noticed the juror sleeping, but later did and agreed the juror would be designated an alternate. So the lawyers are not watching the jury in this case on either side. Borowski mentions it. He's been watching this guy sleep, and then they notice, they're like, oh, yeah, that's not good. That's not good at all. During another discussion in chambers, according to the defense brief, Borowski told defense counsel Colleen Cullen that his clerk and court reporter told him that Cullen rolled her eyes whenever he ruled on objections. He said he hadn't seen it himself, which was lucky for Cullen because it's the judge's biggest pet peeve. So there you go, ladies. If you're ever around Borowski, you want to get him a little hot under the robes, just roll your eyes at him a couple times. Just a little bit. Just give him the old eye roll. Several days after the defense tried to file the post-trial brief, Borowski's clerk emailed parent Cullen and Tom Reed, the regional manager for the state public defender's office. It read, Judge Borowski would like to see the two of you now. Doesn't matter what your calendars look like. No excuses. They're not even in the court anymore. Get in here now. Get in now. Immediately. According to a transcript of a hearing October 17th, Borowski said he was taken aback and shocked by the defense's post-trial brief, which was filed without leave of the court. He said his research found no basis for filing such a document and reiterated that parents and Cullen should have raised timely objections during trial if they believed there were errors and moved to put certain conversations on the record then. Borowski also said the brief contained private and potentially confidential information about the juror and witnesses, as well as obvious attacks on the court. He said a response from the prosecutor, Vance Curzon, indicated he didn't recall some of the conversations or that they didn't happen as described by the defense. Who's shocked by that? The judge also denied making some of the statements the defense brief attributed to him. The defense also obviously took it upon themselves to attack me personally. For Miss Cullen and Miss Parent, I'm disappointed. Ouch. Ouch. It's like talking to my own dad. Borowski said several evidentiary rulings he made in favor of the defense weigh against any claim that White could make that his counsel was ineffective. One he cited was a decision to allow a doctor to present at best a novel, experimental legal theory as a defense expert and to instruct the jury on self-defense. Borowski also addressed his comments about the Blackney matter during White's trial. The defense took it upon themselves to use my being honest. At that point, a vulnerable, frustrated adult who was having a bad week to turn that into an attack. He said, it's not easy being trashed in the media or on talk radio about a decision you made. To have that turned around on me and act like I'm some bad person is disappointing. He said, it's hurtful. And yes, I would expect better from any attorney. Lastly, Borowski said the administration of justice required him to seal the documents and that doing so had bearing on White's earlier public trial. He rejected parents' attempt to make a further record after his lengthy oral ruling. Some lengthy oral. Okay. You needed to make the record 7 weeks ago. Denied. Denied. Both Parent and Cullen have left or are leaving the public defender's office. Parent said the White case was not the sole reason, but was kind of a last straw. The judges are most vocal about the lack of defense attorneys are the ones that treat them the worst, Parent said. Borowski held a hearing with the prosecutor and Reed. The judge set an October 14th deadline for the defense and prosecution to file briefs addressing what legal authority supported filing its brief to complete the record. Those briefs were also sealed. Borowski has been a circuit judge since 2003 and has been reelected 3 times to 6-year terms, the current one running until 2027. He is known for the occasional temper and outbursts towards parties, lawyers, or people in the gallery who he perceives are not behaving properly, but he's generally respected by lawyers as fair and effective at handling serious cases. And again, from the Theodore Edgecombe trial, I saw nothing but that in that trial. He was professional. He handled the courtroom. He managed it well. Borowski has ordered contempt detentions for parties in probate cases and a lawyer in a high-profile fetal abduction homicide case. His decision to hold an assistant public defender in contempt during a bail hearing in 2018 resulted in widespread backlash amongst the defense bar and a reassignment to misdemeanor court. And here I think we might have some of the source on this, right? Judge Borowski needs to be reined in. He's a mean old judge. It's mean. It's not fair. On October 4th, Chief Judge Mary Trujillo reassigned Yamahiro to Borowski's calendar of major felonies. and Borowski to Yamahiro's civil/probate caseload starting October 31st. Yamahiro had just moved to the probate division in August during the usual judicial rotation period, but Borowski will still handle White's sentencing set for November 10th. Borowski said it was a mutual decision among the 3 judges, and he will be glad to take a break from the major felony calendar. So that is what's been going on with Judge Borowski. So he has moved over to the probate court as a mutual decision. Right after the usual rotation occurred and he wasn't moved, it was a mutual decision to move him. I'm sure it was extremely mutual. In Kermit voice, I doubt it.